Ladies and gentlemen, the American Jury and Bulldog Nation, welcome to the next segment of Eric Deters, the Law, where I give an instructional, educational video about legal subjects that are of interest to you. Yesterday, we did criminal procedure. I'm actually probably going to do a follow-up. I thought of some other things, so we might do a criminal procedure too, and I wouldn't be surprised if there's going to be a civil procedure too. When you say civil procedure, you're talking about litigation that doesn't involve crimes. It usually is between people. I want to stress this to you before I start on my first category there, lawsuit. Civil procedure involves litigation involving two parties or more than two parties. There is a plaintiff in the lawsuit, and the plaintiff is the person who brings the lawsuit against the defendant whose the lawsuit is against. In one lawsuit, there can be multiple plaintiffs and multiple defendants. It's that simple. However, it's important for you to remember that litigation isn't just between people. It's also between companies, business, individuals, and people. And I want to stress this to you, and it's very important for you to know this. Do you realize that there's more litigation and more lawsuits between two businesses than there are individuals who get hurt? Because the media has stirred that up, that there's all these frivolous lawsuits, which is really a crock. A lawsuit is what begins the process, and it's also called a complaint. That's actually the official name of a lawsuit. It's called a complaint. Sometimes they're also called petitions. There's different avenues, depending on what you're doing, like a petition to dissolve a piece of property and divide a piece of property up. It's called a petition instead of complaint. A lawsuit is usually drafted by a lawyer, of course, who interacts with their client, gathering all the information that's necessary to proceed. Every lawsuit contains the following: facts, and then what we call claims or counts. And those claims or counts are those claims that are relevant to that set of facts and the law. For example, if you're injured in an automobile accident, you detail the facts of what happened, and then your number one claim or count is for negligence. But that's what's contained in the lawsuit. And every lawsuit covers where the action happened, the facts, the law that applies to it, and what's called a prayer for relief, or what you're asking for. Usually it's for monetary damages. That's usually the only thing that you can get. But there's other prayers for relief. Now, once a lawsuit is filed in the clerk's office. If it's a state lawsuit, it is the circuit or district clerk's office or the county clerk's office. This is really important. In Kentucky, we have district court, circuit court. We have a district clerk and a circuit clerk. Usually they're the same person. In Ohio, it's just the court of clerk's office. They don't separate those out. When the lawsuit is filed, a summons is issued with that complaint, and they have to be served on the defendants. No lawsuit can go forward until the defendants actually receive notice of the lawsuit. Now, in Kentucky, when you get served a lawsuit, you can get served by the sheriff or by certified mail. In Kentucky, you have 20 days to file an answer, or what we call otherwise plead. In Ohio, you have 28 days. So you can be served by the sheriff. You can be served by certified mail. Sometimes you get a special process server appointed if you're having a hard time serving somebody. Ohio allows regular mail service as well. Now, every lawsuit, you have to take into account the jurisdiction first. What is a jurisdiction? Well, if the case is under $4,000 in Kentucky, you're going to have to file it in district court. Small claims I think it's 2,000. They might have increased a little bit. Small claims, you're going to be filing it in small claims court. By the way, small claims is when you have a small matter, you get a court date, you show up. It's just like people's court. District court handles small matters involving money. Circuit court handles bigger matters. Now, in federal court, you can bring a claim for federal court if it is a federal question. In other words, it involves a constitutional issue. You can also file in federal court if you have what's called diversity jurisdiction. And what diversity jurisdiction means is you're in one court or another court. You're in one state, the other party's in another state. You have what's called diversity jurisdiction. By the way, backing up to this, venue is where it all happened. It's where it's all happened. So if it's Kentucky case, it's got to be in Kentucky, in the county where the matter happens. Now, a lot of times you got options on venue. You can maybe bring it where you live or where the other side lives, where the contract was made, so forth and so on. By the way, the cases that are filed in civil court include the following: actions for money, actions for negligence, actions for partitioning property, anything involving real estate is a civil case that has to go forward. Medical malpractice, civil case. Disputes between neighbors, civil case. Those are all covered in that. Now, going on now, back up to the next district or municipal. District in Kentucky, you have district court is the small matters. In Ohio, it's municipal. In larger matters, circuit court, common pleas court. U.S. District Court, I've already covered some of that diversity. You file the lawsuit in the clerk's office. Just to let you know, everybody's going to electronic filing now. You can take stuff to the courthouse, but it's usually done electronic. It's kind of sad. You got to have a credit card now to practice law. You used not to have a credit card to practice law. Now you do. Now, once a lawsuit is filed, the other side can file what's called an answer. They have a certain amount of time to answer. However, before that happens, you can file, and these big law firms and defendants do this all the time, a motion or request to dismiss it, saying the jurisdiction is wrong, saying the venue is wrong, saying that based upon what was pled, there's no cause of action. In other words, exactly what was pled means what you stated doesn't arise to a claim. Very common to start out a case with a motion to dismiss. If your motion to dismiss is overruled, then you have to file an answer. And that answer has to admit or deny each and every allegation that's contained in that lawsuit. From the time the lawsuit is filed all the way to a trial date, you have what's called discovery. And discovery is what takes all the time. Discovery involves paper discovery. It involves oral discovery. It involves investigations, whatever you got to do, photographs. Now, it's very common in litigation for both sides to exchange what's called interrogatories. Those are questions that you get to preliminary ask the other side. The other thing is requests for admissions, where you make them either admit or deny certain salient facts that are going to help you prove your case. Then there's also requests for production of documents, where you have to produce documents that they request. I want to stress this. This is very, 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 very important. This process is where all the battles happen. People don't want to give up certain things. You got to file motions to compel. It's called a request to compel the other side to produce what you want. And there's all kinds of battles relative to discovery. There are sometimes things are confidential, so you get into the idea of protective orders, confidentiality orders, all kinds of things. This usually takes place with the parties. Now, subpoenas is where you subpoena third parties' information. So let's say you got a case against St. Elizabeth Medical Center. But you want some information from a physical therapist's office. Well, you can subpoena those records directly. You have to give notice to all the parties. After the biggest part of the discovery is also depositions. Here's a deposition. A deposition is a sworn interview. Lawyers interview or question somebody. It's all transcribed. Both parties have an opportunity to question the witness, and then you have a record of that witness. And those depositions can be used at trial. They can be used to impeach a witness, but there's no longer, this is a big issue for you to understand. There's no longer trial by surprise in America. There isn't. You've got to disclose. In these interrogatory process, they ask you, who are your witnesses? You got to tell them. If you don't tell them, you don't get to call them. Same thing, depositions. You get to ask all the questions. So by the time the trial comes around, you already know what the other side's going to say and do. They already know what you're going to say or do. If it's a really good case, it'll settle. Then there's experts. Experts are only necessary when there is an issue that is outside the realm of an average Joe person. So you might understand that if you got a police misconduct case, you got to have another cop or another expert who testifies what he did was right or wrong. If it's a medical malpractice case, you got to have a medical expert in their field that can say that spine surgeon did XYZ wrong. For example, in the Durrani litigation, where Dr. Durrani is an orthopedic spine doctor, we call 3 experts in every case. 1, an orthopedic spine doctor. 2, a neurosurgeon. 3, a neuroradiologist, because Durrani always lied about the films. We call those 3 experts in every case. You have to. If we didn't have those experts, we could not get to the jury. The case would get dismissed. A trial, unlike, like a criminal case, you can choose a bench trial or a jury trial. Unlike a criminal case jury that has to be unanimous when they do a verdict, it can be 9-3 in Kentucky when you have a 12-person jury, 6-2 when you have an 8-person jury over in Ohio. It does not have to be unanimous. You can still have a hung jury, by the way, in a civil case. And then depending on who wins and loses, there's post-trial motions. And then, of course, there's appeals just like there are in criminal cases. And either whatever the jury decides will be upheld or it'll be reversed. And sometimes you lose or you just retry the case again. This has been a very soft overview of the civil process. I intend on doing other extensive videos getting into the gritty details of the process. I'm going to be doing a lot of videos, so I'll have time to do them. Remember, if you got a question, you can email me at eric@ericdeters.com. Text me at 859-250-2527, and I will reply. Tomorrow, I think we're going to dig into medical malpractice. This is the Bulldog. Every dog has their day. Have a great day.